May it please the Court, my name is Walker, initial K, and I am the counsel representing the defence of 14-year-old boy Darren Selders, who identifies as Torres Strait Islander. My client has been convicted on account of breaking and entering and stealing. The defence submits the application pursuant to Section 590(a), which details pre-trial directions and rulings specifically relevant, subsection 2, paragraph E, which states that the court may give directional ruling in deciding questions of law, including the admissibility of the evidence and the steps that must be taken in evidence to not be admitted. Your Honour, the defence asks that you exercise your discretion in excluding the Crown's evidence on the grounds that the evidence, the confessions my client made in the police car at the time of the arrest, and the confessions made once back at the station during police questioning, were obtained unlawfully and unfairly by the police officers. Whilst the evidence provided is admissible, it should be excluded on two grounds: public policy and unfairness. Firstly, the confession obtained during the arrest and once back at the police station contravened multiple statutory requirements, therefore contravening public policy. Secondly, admitting the confession as evidence would be highly unfair as it has substantial prejudicial weight and my client only made the confession due to gratuitous concurrence. Your Honour, according to Section 431 of the PPRA, the police officers are required to caution a person of their right to silence. This did not occur when my client was arrested on the 20th of March 2019. The police officers did not take Master Selders straight back to the police station, but instead drove by a number of properties and questioned Master Selders if he had committed crimes there as well. This was unnecessary and unfair as my client was not required to answer these questions, and even once he was back at the station, the social worker that he was assigned to my client did not advise him of this right either. Whilst the support person was provided, they were unknown to my client. According to Section 420 and 421 of the PPRA, the officers were required to inform ACSILs or legal aid and inform my client they were doing so. The organisations they were required to call were set out in Sections 420, 421 and 26 of the PPRA. Section 418 also states that the relevant person has a right to communicate or contact a friend, relative or lawyer. None of these regulations were complied with. Section 420 and 421 also state that an officer must not question the child unless the child has spoken to a support person or that chosen support person is present. The officers did not comply with this regulation. My client's confession should be excluded under the public policy discretion. Your Honour, may I point to you the Bunning and Cross case, where the police officer in that case did not comply with the regulation also. The court excluded the evidence obtained because of this discretion. Likewise in the Island case. Furthermore, it is a requirement, according to Section 437 of the PPRA, that as soon as reasonably practical after the questioning is finished, for the officer to take a written record of what was said. Subsections 4 to 7 details the confession is then to be discussed with the person of what the record says, a copy given to them, and a chance for the person to correct any errors. The officers who arrested my client deliberately breached their duty to do all the previously mentioned obligations and therefore have obtained evidence that is unreliable and unfair to my client. The 5 factors set out in the Bunning and Cross case confirm that public policy discretion should be exercised. The first factor is whether or not the conduct resulted from a genuine mistake or deliberate breach of law. The confession was not obtained through genuine mistake, and normal procedure would have easily been able to be complied with. The second factor provides that if it had been gathered due to a genuine mistake, then the contingency of the evidence can be taken into account. However, Your Honour, this is not the case, and it is not vital evidence and therefore should be excluded. The third factor considers the circumstances in which the evidence was obtained. In this case, there was no pressing circumstances that required the officers to not comply with the legislation, consequently allowing this evidence to likely be excluded. The fourth factor considers the charge itself and the seriousness of it. The offence itself that my client is charged with, breaking and entering and stealing, is not serious in comparison to, say, murder. The fifth and final factor considers the statute that has been breached in order to obtain the evidence. The statute, the PPRA and the PPRR, that has been breached was there to prevent confessions being unfairly extracted from accused persons like my client. Secondly, the substantial prejudicial weight of the confession would create an unfair trial for Master Selders. Your Honour, it would have been so easy for the officers to comply with the law. I turn your attention to the case of Crown and Christie, and the Crown and Hasler, and the case of Lee. These are three cases that also deal with the fairness discretion, or as I'm sure you're aware of, the Christie discretion. The officers in our case today failed to appreciate and realise the cultural mannerisms of my Indigenous client. The evidence in question today may to some look like an admission of guilt. However, these positive responses given to the police officers are common with Indigenous persons showing gratuitous concurrence. Indigenous persons are likely, because of their cultural heritage, to just agree or give a positive response when they are faced with the person of power to simply end the conversation quickly. This was failed to be seen by the officers dealing with the arrest. Similarly, this explains the lack of eye contact my client gave when speaking with the officers. The Christie discretion is in existence to exclude evidence where it is prejudicial to a fair trial. Similarly, in the case of Hasler, where the evidence in question is of slight probative value, but the prejudicial effect, if admitted, would be substantial. Your Honour, this can be seen as the case here as well. If the evidence of the confessions made by my client admitting to guilt is given to a jury, it's highly likely that they would give it more weight than it deserves, simply as they may not take into consideration or have any experience dealing with Indigenous people's cultural mannerisms. Your Honour, may it please the Court.